Hello everybody, I'm Seth Weissman and welcome to another episode of Safe Real Estate. Today we are going to talk about tax prorations, and specifically what we're going to discuss is the situation where the closing takes place and then after the closing the buyer has to pay significantly more money than what they contemplated because the proration was based on an estimated tax bill, and the actual tax bill is then substantially higher. And the question is, when that occurs, does the buyer have any legal recourse against the seller? And the answer under the GAR purchase and sale agreement is yes. The buyer can go back to the seller and demand that they reprorate the tax bill and that the seller reprorate and pay their portion of the tax bill based on the actual tax bill, not based on the estimated tax bill. Now, unfortunately, when buyers do reach out to sellers and ask for the tax bill to be reprorated and adjusted between them, some sellers will not respond. Some sellers will simply ignore the request, knowing that the buyer has limited remedies. But in theory, at least, the buyer does have recourse where they can bring an action in small claims court or in state court to force the seller to pay what the seller should lawfully be obligated to pay under the GAR purchase and sale agreement. Rarely does it result in litigation, but that is a remedy that the buyer has. I hope this episode of Safe Real Estate has been beneficial. As always, it's great to see everyone. Please continue to tune in. Bye now.